A button. So let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started on this lovely, beautiful Friday. Isn't it just beautiful out there today, my friends? It certainly is. Are the tubes connected? I do believe they are. That's tremendous. That means we can go ahead and get started. We're over on Rumble. Cool. Let's do it. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Govea, and today we are talking about Trump trial schedule. We have a date that has been floated around for when Donald Trump wants his case to go forward. And it's not anytime soon at all. We're talking about 2026. And so it's a fun date. And I think this makes a lot of sense. I mean, I think it's a perfect date. I'm glad that they've picked something reasonable here because remember, there were 11.5 million documents that they were allegedly needing to go through. The government assembled them all. They're like dropping them off in a wheelbarrow. They said, hey, we did put it in a spreadsheet for you though. So like you can forget about half of it or whatever. And of course, as we know, from a defense perspective, we appreciate their efforts from the corrupt DOJ, but we're just going to go ahead and review the evidence ourselves. So they've said, based on this massive volume on this ridiculous case, we're going to need some serious time in order to properly vet the discovery and get into this. So we'll go all through the actual scheduling memo that Trump's team submitted. Trump is canceling the event on Monday. We were kind of looking forward to that. Probably a good decision that they're not moving this forward, but we still were kind of curious to see if there was going to be anything exciting that came out of it, but that's been canceled. Now, Rudy, previously this week, we had some conversations about Rudy and his position. We saw that MSNBC was saying he was in a little bit of a precarious position in terms of finances. He's got all this litigation going on, Dominion, Smartmatic, like electors, all these people are just suing him. And it's, curious that those same entities weren't suing the Democrats when the Democrats were making their claims about stolen elections, but we'll leave that. But Rudy, he comes out and he says, Fani really doesn't know what she's doing. A lot of people know Rudy as somebody who was behind a lot of RICO prosecutions during his day as a prosecutor. And he's referencing the removal statute, the same removal statute that Mark Meadows is using to try to get his case removed out of Big Fani Willis's state court up into federal court so they can get a better, let's say, forum than in Georgia. Now, there's a long interview from Bill Barr. We're going to jip a little bit of this. But man, this guy's like all over the place. So Bill Barr says Trump is the worst, but he might vote for him. And he says that the DOJ prosecutions, even though the DOJ, when they were trying to impeach and smear Trump without any probable cause before with the Steele dossier, FISA warrants and all the things, that was illegitimate and problematic, but these new DOJ prosecutions brought by Jack Smith are suddenly above board and they're just amazing. He's also saying, though, that Georgia is overbroad and it's actually a pretty bad case. And he's saying there's no way that Georgia actually goes forward before the election. And I agree with him on this. So we'll listen to a little bit of that and see what Bill Barr has to say over in this first segment. Then we'll see what's happening over at the federal level because the judge in the federal court for the District of Georgia has granted the removal hearing. Now, this doesn't mean that the case has ultimately been removed, but they are granting a hearing on this, which means that facially, Mark Meadows' request to take this case away from Big Fani is moving past the next step. The initial hurdle has been met and the judge is issuing the order. So we'll read through the order. Something interesting has been happening here. Remember, there were 18 other co-defendants aside from Trump, and other people are going to be filing the request to remove. They're saying the Federal Supremacy Clause says that if you are a member of the executive branch, in this case, like Mark Meadows, and you remove this up, and basically you were acting under the purview, the umbrella of your service, in this case, he was the chief of staff, that gives him permission to remove this up. But maybe some of the other co-defendants in the case don't have that same ability because they weren't obviously chief of staff. So he's saying, you've got to handle my case alone. I don't want any delays on this. And he's also saying that Big Fani might be dodging service of this. Like she doesn't want to show up in federal court. Like she just wants to let this whole thing slide under the rug or something. It's bizarre. We'll check in with Ratcliffe, former director of national intelligence. He's saying that this is all basically political. You know, they launched all of these in the last 4.5 months. They had evidence they could have brought previously, but they haven't done it. And so we'll see what he has to say. And then lastly, boy, this guy is one of the most obnoxious people that I think we've had here on this channel. Even Joe Scarborough. They're like allies. They're both trying to defend Hunter and Joe Biden, but they still get into it. He's like, don't you dare ask me questions about Hunter. And so we'll go through that. This is Abe Lowell. And we've read through some other letters from him. Like, man, talk about the snark on these guys. Hunter just finds these lawyers that are just extremely aggressive. And we'll go through it. It's fitting just for Hunter. But he's basically telling Joe Scarborough, you're too dumb to know what's happening here. Hunter's much smarter than all of us, including you. Don't ask me about $7 million. Okay, it's you're part of the problem, Joe. It's a very aggressive interview. And Joe is even like taken aback a little bit. So it's kind of a fun thing. Then we'll check in with the cases because the judge dismisses the tax charge. And we talked about this very quickly at the end of the show yesterday, but we'll just pause on that. We'll also look at another order from Judge Norica, which is denying the seal request from the government. Remember, they said, actually, it was Hunter's, I think, request to seal. So yeah, denied Hunter's request to seal, not the prosecutors. Wants the record out on the open and kind of calls the Hunter defense team a bunch of liars. We've also got a clip from James Comer saying that all these fake pseudonyms from Joe Biden are going to lead to more connections. It's just going to be the opening of the Pandora's box. You see, Jake Sullivan had a rough night out last night. He was there, I don't know, must have been probably trying to track down Hunter Biden, scurrying around the gutters somewhere. So he had a rough day. He got asked about the implications of Hunter and China and Ukraine and all of these things and whether it was a big problem because, you know, he's national security advisor. So if like foreign influence, it's kind of in his jurisdiction. But we'll see what he has to say about that. And then we'll wrap up this lovely Friday with a fun comment from Jake Tapper over at CNN, who basically says, yeah, Trump was right. Joe Biden's a big fat liar. He didn't say it that way, but he'll, you know, more or less, that's kind of what he was getting at. And so we'll go through it today, all in the show. And my friends, if you want to be a part of our amazing community and part of the program, we would love to have you as a member. We had a very fun members only stream this morning. Our members, we've got a lot cooking. So members only live stream tomorrow. I've got an interview scheduled with my friend Sanjeev, and he's coming here and he's going to hang out. We're going to experiment on the new interview setup that I have right behind this camera. And so it's going to be a lot of fun. And we're taking questions from our members, locals. You've got your form. We sent it over to the YouTube members. And so kind of want to get a gauge. Sanjeev is brilliant. He can talk about anything health related. So he'll be here and we're going to do a private members only live stream. Going to be a little, you know, authentic and raw and real. We don't have, it's just us. We're just playing around with the setup. So if you want to come check that out, should be tomorrow, give or take 2 p.m. Eastern time. Time is still TBD. But we have a survey. So if you want to check out the survey and say what you want to talk about, let us know. Should be fun. watchingthewatchers.locals.com. Check out our website, robertgovea.com, so you can get the show reports. If you don't have time to watch a full video, you can read the daily reports. There's also a tutorial there on how to use the mind map if you want to navigate around and get access to PDFs or the video files or any of the links that you see here on the show. You can do that all at robertgovea.com. We also want to be healthy. Tomorrow, we're talking about a lot of health, and we'll talk about not only nutrition, but performance. But today, we want to lose those leftover pandemic pounds. And we know that it's getting a little bit tired of all the ads for the weight loss pills, the fat diets, and all this stuff. But it is something we have to think about because we have to find what works for us. You know what might? Eating 5 healthy servings of fruits and vegetables every day. You do that and the weight would probably just fall right off. But look, vegetables, I know, not a fan. And fruit, who's got time to prepare that every day? I don't. Instead, let's talk about Field of Greens, which is a science-backed formula of specific fruits and vegetables that you're not going to find in any other product. Proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you're going to look and feel healthier fast, baby, but the greater proof is going to come at your next checkup when your doctor says, whoa, you have lost weight. Whatever you're doing, keep it up. And so let's get you started. Go on over to fieldofgreens.com. Fieldofgreens.com, and you can save 15% off with code Robert. And it's important to remember that the vegetables want to be eaten, okay? You don't even have to feel bad about it. All these people lecturing us, this will kill you, this will kill you. The vegetables, that's why they're here, man. They pop out of the ground. Look how colorful they look. They're like, eat me. Fieldofgreens.com, code Robert. All right. Now, yeah. Going to ask him, we're going to ask Jeevers about Dianne Feinstein's face and whether it's normal or not. Yeah, it's a good question. I don't know. He'll be able to explain that one. Might need to talk to a priest. All right, so let's get into it. Donald Trump wants a trial scheduled, and he wants it done reasonably during a time frame that is responsible, which happens to be 2026. Now, we know the election is in 2024. So a couple of years after the election seems about right. And a lot of people on the left are laughing about this, kind of screeching and shouting, going, oh, 2026. What's like the midterms? Yeah, after Donald Trump has won, and after the first 2 years of his successful presidency, yeah, then we can have a trial and see how it goes. But the point is, there are 11.5 million documents, give or take, the government is still assembling it all, that they say is part of discovery that needs to be delivered over to Donald Trump and his defense team. And so his defense team put together a brilliant memo. It's got charts and graphs and numbers and all sorts of stuff. And we'll read through it to see what their argument is for why 2026 is justified. We have also got reaction from Rudy, who's roasting Big Fani Willis in Georgia. And even Bill Barr is saying, yeah, the Georgia case is pretty garbage. So let's jump right into the memo. You see here, this is the response. 16 pages. We got some charts and graphs. It's beautiful. In the United States District Court, this is the D.C. case. We're talking about January 6th. Government versus Donald Trump. This is Trump's response. So Trump is responding to the government's proposed trial calendar, and it's in opposition, right? Remember, the government said we could get this done like lickety-split. We'll have a trial immediately, and I think they said that the trial would start, according to them, they said opening arguments, they wanted it to start in January of 2024, with jury selection being picked in voir dire taking place in December. So Trump is saying, no. How about no? Trump, through his lawyers, respond in opposition to the original request. And here's what they say. They open up with a quote referenced from a 1932 case from the United States Supreme Court called Powell versus State of Alabama. Quoting, "The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. To do that is not to proceed promptly in the calm spirit of regulated justice, but to go forward with the haste of the mob." United States Supreme Court, 1932. Slow down, lest we become part of the mob. Trump's defense says, "This is an unprecedented case in American history. The incumbent administration, Biden, has targeted its primary political opponent and leading candidate in the upcoming presidential election with criminal prosecution. The administration has devoted tens of millions of dollars to this effort, creating a special counsel's office with dozens of employees, many of whom are apparently assigned full-time to this case, and this case alone. Taking full advantage of the administration's blank check," footnote 1, referencing the DOJ expenditure report, reporting $5.4 million in direct expenditures, another $3.8 million in DOJ components. Lots of money being dumped into this. And remember, Trump has to come and meet this. He's got to hire his lawyers, and they've got to hire their staff. So it's draining his resources that could be used for campaigning. All intentional. And this doesn't cost them anything, because you know who's paying for this? We are. Biden and the special counsel and the government spent over 2.5 years investigating this matter. It, among other things, interviewed and subpoenaed hundreds of witnesses, executed over 40 search warrants, compiled information from countless individual sources. Trump's team says the government included some, but not all, of the materials in a massive 8.5 terabyte initial production, totaling over 11.5 million pages, together with native files, recordings, and other electronic data not amenable to pagination. So we don't even know how many pages it is. In this district, Judge, ordinary order, when faced with such overwhelming discovery, is to set a reasonable trial schedule, commensurate with the size and the scope of discovery and complexity of the legal issues. The government rejects Biden's special counsel, rejects this sensible approach. Instead, they seek a trial calendar more rapid than most no-document misdemeanors, requesting just 4 months from the beginning of discovery to jury selection happening in December. Jack Smith and Biden's objective are clear: to deny President Trump and his counsel a fair ability to prepare for trial. The court should deny the government's request. They say the public interest lies in justice and fair trial, not a rush to judgment. And moreover, if the rights to due process and counsel are to mean anything, a defendant must have adequate time to defend himself. The Speedy Trial Act embraces these considerations, and so too should the court. Accordingly, President Trump, Your Honor, respectfully requests the court schedule this case to begin on the April 2026 trial calendar. 26, with the following interim control dates. The week of December 4, 2023, a discovery and status conference with a motions hearing. Then we'll fast forward to April, another quarter, another discovery status conference. We'll jump out to August 2024. Then we have discovery status and other motions, and you can see that it just goes on and on, right? A lot of motions hearings. So we'll hit the dates. August 1st, August 22nd. So it looks like two updates in August, 3 updates in August. August 5th. Then we have September. We've got other motions, another motions hearing, more discovery status conferences. So basically what they're asking for, I believe, is they want the judge to check in on them, to say, okay, how many millions of pages have you done? Right? These are basically all the same thing. Status conference motions, status conference motions. So the way this will work is, think of it like a process where the government delivers a batch of files. They say, hey, this is our batch 1. You say, okay, cool, let me take a look at it. What do you say is in batch 1? They say, here's what's in batch 1. It's officer A, B, and C. You say, okay, great. We got batch 1, officer A, B, and C. We say, okay, all right. But this references officer W. And so we're going to need officer W. And also, you also reference this report. So we're going to need this report and this report based on what we found in your batch 1. So what we're going to need are supplemental filings. So we want all of this other stuff. So just think of all the branches that come off just from one batch, right? We say, okay, you've got this. We need Officer A's background. We need his apparently he was disciplined in this. We need his personnel file. We need this, blah, 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 and so on and so forth. And then they say, no, you don't get that. No, we're not going to give you this branch or this branch or this branch. We already gave you what we felt was conclusive. We know about that. We know about that. We know about that. But we're not giving it to you because it's outside the scope of the case. And the defense says, the heck it is. So we need it. And we need to talk to the judge about this. So see you in court. So that's this process. Okay. It's like this little roundabout, this circular thing that happens. There's a delivery. There's a request for supplements. There's probably a battle over it. The judge will decide it and you'll do it again. So that's what's happening here. A status conference and a motions hearing so that when they say, hey, we need this thing, the judge can deal with it. And that process will go around and around again. So, in 2024, they'll come back and they'll say, yeah, we got through about 2 million pages, give or take. 2 million? Wow. All right. We'll get back to it. So they come back August 4th. How many more pages did you get through? Oh, judge, man, it's been a long time. All right. August 4th. It's been like months now. December is our next status. Okay. So we've got a full year. We did another 2 million. So maybe it's 2 million. To get to 11, we're going to need to go a lot faster than that. So we're going to need to break it down, right? You do the math, the calculations, but 3-4 million a year until we get to 2026, and just do the calculations on it. So then we get to our final pretrial conference in March 2026. Maybe they'll give us some breakdown of what they intend to do. But you get the point. All right, we'll do 3 million here, 3 million here, 3 million here, and updates the entire time. Now, motions in limine are the more substantive motions. That's to say, all right, well, based on the discovery, we don't want this witness to be able to testify. Based upon this evidence that they've given to us, we don't think that this issue should even be discussed. And so then we're having this battle, and this is all taking place, like this section is right before trial. So April is when jury selection would start. The rest of this is hearings, motions in limine, all the preliminary motions. But the rest of this is just that discovery circle and arguing over discovery as we go through 11 million documents, plus the videos, plus the non-paginated documents, and so on. So you see, like, that seems a lot more reasonable, because it's hard to go through 11 million documents in 4 months, right? Because that's like 2.5 million documents a month. Divide 2.5 million by 30 days. I don't know what that is, but you're going through millions of documents quickly, right? You're going through them very quickly, basically impossibly quickly. So they say, Your Honor, obviously, this is a more reasonable schedule, equal to the government's time spent investigating the matter. And it's going to allow this case to proceed in an orderly fashion, with both parties having a fair opportunity to review all the material, advance the appropriate motions, apprise the court of relevant legal issues, and additionally, Trump's proposed schedule will do the following. It's going to avoid scheduling conflicts with other things. It's going to give us plenty of time. We've got other prosecutions brought by this corrupt government. We also have to provide sufficient time to address the production of the discovery under the SEPA rules, because they did acknowledge that there was a small batch of classified materials even in this case. And 3, to preserve Trump's right to seek discovery from third parties, right? Because he might want to go send some record requests over to the DOJ or to, let's say, the Capitol Hill Police or the Metro Police, or maybe he wants to go dig into some other allegations in other states, or who knows where this could go, but it could go big. He says, while also addressing significant gaps in the government's productions, and they're going to need a lot of time. I could go expand that branches out massively. So they say, Your Honor, at this early stage, without having reviewed the discovery, President Trump cannot estimate the time that he's going to require to present the case at trial. However, for the present, without any waiver of rights or arguments, when we actually get to trial in April 2026, President Trump will adopt the same calculation as the government, 4 to 6 weeks for the defense case, all right? So a month, maybe a month and a half for the government, 6 weeks, they present their case. Trump gets his own 6 weeks for the defense, they say. In setting a trial date, Your Honor, a court must allow Trump and Trump's lawyers, quote, reasonable time to prepare. Because stripping away the opportunity to prepare for trial is tantamount to denying altogether the assistance of counsel for the defense. And for that reason, the Speedy Trial Act, which oftentimes, right, this feels a little bit strange because sometimes you'll see the defense wants a trial done quickly. The Speedy Trial Act directs the court to consider the unusual or complex nature of the case, and then the need to provide lawyers for the defendant, in this case Trump, reasonable time necessary to prepare for effective preparation, also taking into the account the exercise of due diligence. That's the code. Whether a delay is reasonable, whether this is justified, depends on a lot of things. The length of the requested delay, it's a long time, 2026, that's obviously a long time. But not that long. We see a lot of other criminal cases that take years. How long did the Ghislaine Maxwell case take? The length of the requested delay, whether other continuance have been requested or granted, the balance convenience or inconvenience of the litigants, counsel, whether the requested delay is for legitimate reasons or whether it's dilatory, whether the defendant contributed to the circumstance which gives rise to the request for continuance, whether they were competent counsel or here, and so on. All of these are various factors. They say, Your Honor, we also appreciate the heavy caseloads that the courts are under. And we understand how you're operating and your interest in expediting trials. We feel compelled, though, Judge, to caution against the potential dangers of haste and to reiterate that an insistence upon expeditiousness in some cases renders the right to defend with counsel an empty formality. We're going to have some constitutional problems if we go too fast here. In our system of justice, the Sixth Amendment's guarantee to assistance of counsel is paramount, ensuring the fundamental human rights of life and liberty. They say the Sixth Amendment stands as constant admonition that if the constitutional safeguards it provides be lost, justice will not still be done. So here's the argument. Your Honor, this is why we need to bump this thing all the way to 2026. 11.5 million pages is a difficult number to comprehend. Ordinarily, a complex, document-intensive criminal case might have maybe 1 million pages at issue. They say here was one example, U.S. versus Scarfo. This was an open-ended continuance, and this was a complex case designation under the law. There were 1 million pages of information in that case. 1 million pages. Open-ended, it was designated complex, which means it took a lot longer under the code. If you designate a case complex, you get a lot more time. To have over 10 times that many pages at issue against one defendant, Trump, is largely unheard of. Such cases are instead almost always sprawling civil battles between large companies, which regularly take years to litigate. Here's one example. Walmart versus Visa. That took 7 years to litigate, and guess how many documents that case took? 5 million pages of discovery in Walmart versus Visa. But they want to try this case in January of next year. It took 7 years to litigate that one. They say, to put things in perspective, Your Honor, to put 11.5 million pages in context, we began downloading the government's initial production on August 13th, 2023. 2 days later, it was still downloading. We then requested the government send hard drives containing its initial production, which we received on August 16th. Our technology vendor is now preparing to ingest the files into a document review database, but estimates that such a large data set will take several days to process. Nonetheless, even assuming we could begin reviewing the documents today, we would need to proceed at a pace, there it is, I was hoping somebody did the math, save me, 99,762 pages per day to finish the government's initial production by its proposed date for jury selection. That's some serious speed reading. I'm taking a look at something. I got to deal with something here. All right. So that is the entirety of Tolstoy's War and Peace, cover to cover. 78 times a day, every day, from now until jury selection. Cover to cover, 78 times a day, every day, from now until jury selection. It's a lot of reading. Keeping in mind, this is just to read the government's initial production a single time, to say nothing of trial counsel's need to analyze, organize, integrate those materials into a cohesive defense presentation. Meaning you've got to analyze this stuff. You've got to read it, you've got to ingest it, you've got to take notes on it, discuss it. You don't read a police report in a criminal case also one time. That's nuts. If you have a lawyer who just flips through a police report one time and reads it and you're just done with it, no, of course. You're preparing for trial, you're reading it multiple times, you're doing interviews, and then you're cross-referencing the interview with the report. You go back to the report many times. Oh, what did you say? You said this, but you said this now. Okay, you go back. Times millions of pages. It's insane. Trump's team says, stated differently, If we were to print and stack 11.5 million pages of documents with no gap between pages at 200 pages per inch, the result would be a tower of paper stretching nearly 5,000 feet into the sky. Ah, they've got graphs. Look, they have the Statute of Liberty, 305 feet. The Washington Monument, 555 feet. Information potentially helpful to President Trump, 4,822 feet. Yeah, baby. Look how ridiculous this is. This is paginated portion of this is just the initial production, by the way. This is 200 pages per inch. So if you get so somebody got a ruler out and said 200 pages is about 1 inch times 11.5 million pages is 5,000 feet. It's multiple Washington monuments. I mean, look at these. Like that's another Washington. That's a Washington monument. We've got like, I don't know how many you can fit in there. I mean, that is a lot of Washington monuments. That's a lot of Washington monument evidence. He did try to insurrect the country. I mean, maybe is that was he trying to take the National Archives with him? What was going on? I don't know what's in there. But that's a lot of that's a lot of material. Wow. All right. So they say that is taller than the Washington Monument, stacked 8 times. They did the math. Thank you. Stacked on top of itself 8 times with nearly 250,000 pages to spare. Amazing. Did we count them? 1, 2, 3, 4, 5, 6, 7. All right, I was off a little bit. All right. So absolutely hysterical. Information that's potentially helpful to President Trump and their disclosure. It's 7 Washington monuments plus the original. They say, okay, look, even if this analogy belies the true scope of discovery, it includes only printed text. Without considering native files, we don't even have audio recordings, phone and electronic device image files, and other materials that will require substantial labor-intensive review. The government is already describing hundreds of recordings of witnesses. They describe a hard drive with various returns and extractions that they say are impossible to paginate. So we don't even know, we don't know what the extent of this actual data is because we can't even quantify it. There's no measuring stick to it. Like how many hours of video are they just scanned, limitless, like borderless files that just have odd ends and sizes in their scanning? What's in there? We don't even know. Logs, right? Just logs with like Excel spreadsheets just that go on for 50,000 rows that have GPS records or something like that. Just gobbledygook that they just spit out from some device. They say, likewise, it does not consider the large number of additional documents also, by the way, the 8 Washington monuments, that the government has not but still intends to produce. So it could be 20 Washington monuments. We anticipate additional productions in the coming weeks, and our goal is to have discovery substantially complete by August 28th. They say the government is also going to obtain more going forward. We're going to continue then to produce on the defense on a prompt rolling basis more Washington monuments. We use the term wheelbarrow here, right? I used to say wheelbarrow all the time, like they would just dump a wheelbarrow full of garbage in your front. Not even close. Like an order of, like multiple orders of magnitudes different. It's like not even close to a wheelbarrow. It's a Washington monument, all right? That's how nuts this is. And a wheelbarrow would be nuts. So President Trump may request from the government in discovery, meaning that Trump's going to look at the monuments and then say, I need more. I need like an Empire State Building, and I need a Pentagon. I need a Pentagon. I need a Homeland Security. I need an FBI, and I need a DHS. Send them over. Put them behind the Washington Monument and the Capitol building. All right. So he's going to ask all this stuff, and he may make requests for that stuff. They say Trump may also make requests from third parties. For its part, the government suggests that it has, quote, prepared and organized discovery in a manner that will assist Trump in his review of the produced materials. Which I just love. They're quoting them. They're quoting them. It's like, okay, setting aside the dubious accuracy of this statement, prosecutorial organization of information cannot solve the defense's largest burden, which is reviewing the documents and preparing to use them at trial. Thanks, guys, for your sticky notes. That takes time, a lot of time in this instance, regardless of how the documents are labeled. I can't believe it. So good. Similarly, the government claims that it will provide a compilation of certain key documents and identify certain material within the discovery that is, quote, arguably favorable to the defendant. And we lampoon this when they wrote it. I couldn't even believe they wrote it. It's like, oh, thanks. That's great. This, again, is no answer. The government's view of importance surely differs substantially from the defense. And it goes without saying that a criminal defendant should not build his case on the word of his accusers. Idiots. What kind of even argument was that? We helped you, though. It's nice and organized with little sticky notes and labels, and it's color-coded. And we can't wait to execute you rotten hell. Oh, thanks for this. Yeah, we're going to use it for all of our defenses. Thanks. Have a great weekend. Rather, President Trump has a right to review all the material information regardless of the government's view of the significance of such information to the defense. This is a critically important process, as identifying and presenting Brady material, which is material that might exonerate Trump, will be central to demonstrating President Trump's innocence. Referencing another case, saying the right to present favorable evidence to the jury is clearly established by the Supreme Court. And the government's in a little bit of a pickle here because they can't unring this bell. We already know there's 11.5 million pages. We already know they said that's not all of it. We already, so they can't come back and say, oh yeah, you're right. Sorry, we didn't look up Walmart versus Visa and realize this was double that. We didn't recognize 8 Washington monuments full of literal physical paper. Okay, 8 Washington monuments of physical paper. And what we meant was it's only 500,000 now. We say, oh, no. That's 11.5 million plus some. So get it all over to us. They say we anticipate seeking leave to issue multiple subpoenas. By way of just one example, we would request a subpoena directed at the House of Representatives for documents related to the investigation by the January 6th Select Committee. Oh, yes. That feels good. Let's read that one more time. By way of just one example, Judge, we would request a subpoena to Liz Cheney and Brian Kinzinger's fake, illegally constituted Select Committee for documents related to their so-called investigation. We will also need to address the reported destruction of those documents by that committee, a story we covered here, which was an exchange between a House representative and Benny Thompson, who basically confirmed he sent this stuff over to NARA, to the executive branch, prior to documenting it with the House Archives Committee, which would be potentially exonerative to President Trump. Love that. The government, which investigated this case, destroyed evidence, and that is exonerative to Trump. Even by its own terms, the government states only that it will identify certain, but not all documents it views as significant to its case or favorable to the defense. They acknowledge they might help us here and they might flag this for you and this for you, but not all of it, because they can't make that acknowledgement. They can't say we got everything for you. That's kind of them taking ownership of that. Obviously, they're not going to do that. Thus, whatever limited usefulness the government's key document folder might provide, they say we batched it all and put it in a little index for you, it is not going to alter President Trump's need to fully review all discovery, all 11.5 million pages, multiple times. Additionally, in cases such as this, with... What happened here? Oh, I was reading a footnote. That's why, sorry. With substantial discovery, the court may require that the government to go beyond identifying certain key documents. Right. And the government might be forced to go identify more. It stands as no small irony, they say, that the government seeks to deny Trump his constitutional rights in a prosecution where the government wrongly alleges Trump violated the rights of others. Yeah, it's very interesting how that works, isn't it? Trump's team says, simply put, Your Honor, the discovery in this case is enormous and growing. Although Trump's team will, of course, work diligently to review this material, the process will take some time. For example, even under our proposed schedule, we would need to review approximately 12,000 pages per day to complete a first pass of the initial production by our proposed trial date. 12,000 pages per day. This is an exceedingly rapid pace by any measure, and one that will only be manageable with intense diligence. The government's proposal, by contrast, is just flatly impossible. No defendant can reasonably review 100,000 pages of discovery per day. Thus, even exercising, quote, due diligence, the government's proposal would deny President Trump reasonable time necessary for effective preparation, and in doing so, violates his rights to due process and to counsel. Citing other cases here, this one, 2020, 2014, D.C. Circuit. That looks like it's another D.C. Circuit case. This was a case affirming a continuance, a postponement, in part on the complexity of the case and the volume of discovery. The district court found that the defense itself is not going to be in a position without the additional time. The defense team notes, they say, the government contends that President Trump has been, quote, aware of, this was an amazing statement, that Trump had been aware of certain relevant information made through hearings and the report written by the House Select Committee to investigate the J6 attack, and therefore should not need to thoroughly review discovery. So this is incredible. That's right. They did reference the committee. My one thought was maybe the government would respond to this and say Trump shouldn't get the subpoena for the J6 committee because the J6 committee is not a part of this investigation. This investigation came from Jack Smith. Jack Smith got the evidence on his own. He got it independently. He didn't get it from the J6 committee. And therefore, Trump shouldn't have the right to subpoena for evidence that's not relevant, that's not used in the government, right? I know that's kind of a stretch. I would still argue he should get it, but I'm saying what's the counterattack? So then Trump says, I need that. But Jack Smith says, I already got it independently, so you don't get access to that. Now here, though, the counter to that is that the prosecutors reference the January 6th committee. They say, no, you should just go over there and get it from them. And we also know that the January 6th Select Committee made a referral over to the DOJ. Okay, so they made a handoff. And then they deleted evidence, which could possibly be exculpatory. Or we think they deleted evidence. That's what Benny Thompson says. They turned it over and it didn't go through the proper mechanisms and it might not be there anymore. So the government has included, they've lassoed in the January 6th Select Committee by referencing Trump to go get discovery from them, which is why he doesn't need as much time. So they've actually said that he needs to go get it from them because there isn't enough time to do it independently, right? So he has no choice but to get it from them or should have been watching it and so on. They have, intertwined themselves in a messy way here. The government simultaneously advises only a relatively small percentage of the discovery is non-sensitive, as only non-public material may be marked sensitive. That means Trump had no meaningful ability to review the government's discovery prior to production. This is really good work. That's right. They did say that. They said that it was sensitive in their protective order. They are twisting themselves into a pretzel. They said that Trump needed to go get the relevant discovery from the J6 committee, but most of the discovery that they're providing to him is also deemed sensitive, which is why it needed to be a part of the protective order that they fought about. So Trump couldn't reveal it. So he needs to get it from J6 and he can't get it from J6. And he should have been reviewing it earlier, but he never had access to anything that he can review because it's all sensitive. And by virtue of it being sensitive, it means it's not public. And it's 11.5 million pages of the sensitive stuff. Only a small percentage of that is not sensitive. So he really has no choice but to review the 11 million pages because it's not public. This is good stuff. And so they box themselves in, basically. So the judge, I think is going to be stuck on this in many ways, because it's really 11.5 million pages by their own admissions. And Trump never had access to it. And it's sensitive because they fought. It's so sensitive, Judge. Make us a big protective order. Well, you got your big protective order. Nor would he have known what the materials to review are, as the government did not have any pre-indictment explanation of its theory of the case, right? Let alone identify any information which purports to support those charges. Trump's defense says, at the same time, the government has identified no good reason why it waited 31 months to seek an indictment. The notion that the government may, with all its vast resources, spend years investigating this case only to turn and demand the defense be prepared for jury selection in 4 months defies all notions of fairness. Years for them, couple months for Trump. He should have been investigating the January 6th Select Committee, but that was all public. But we also have 11.5 million pages of sensitive material that we can't make public. That's why we need a protective order. The defense says, without a doubt, the public has an interest in the prompt resolution of this case. Surely. However, as the Speedy Trial Act recognizes, that interest must yield to the public and the defendant's overriding interest in a just proceeding. The proposed schedule allows President Trump to defend himself fairly. The government's proposal does not. Accordingly, the court should adopt our proposed schedule. They say the complexity of this case warrants it. The large volume of discovery in this case is not happenstance, Your Honor, but it reflects the reality of this complicated and unusual case. There are hundreds of potentially relevant witnesses spread across the country. Many are current or former government officials, including with the DOJ itself. Events alleged in the indictment and which are otherwise pertinent likewise occurred throughout the country. Classified documents are at issue, as well as large quantities of search warrant materials that may be subject to suppression. File a motion to suppress that evidence. Whatever came after a bad search warrant should not be admitted as evidence. As noted above, President Trump will seek discovery from government departments and other witnesses, as well as pretrial subpoenas, and this may raise a host of other difficult issues for the court to resolve. These factors alone suggest this case is complex, under the meaning of the laws, and weigh in favor of a lengthier trial calendar. However, this case is not just complex or unusual. It's terra incognita, unrecognized ground. These protests at Capitol Hill aside, no person in the history of our country has ever been charged with conspiracies related to the Electoral Count Act. No president has ever been charged with a crime for conduct committed while in office. No major presidential party candidate has ever been charged while in the middle of a campaign, and certainly not by a DOJ serving his opponent. These and numerous other issues will be questions of first impression, requiring significant time for the parties to consider and brief, and for the court to resolve. The proposed schedule provides that time. The court's government timeline does not. Consequently, the complexity and unusual nature of this case favors Trump's proposed schedule. They say the government also acknowledged that it considers materials that it got from the Congressional Committee and the Secret Service as material to this case. So if that evidence is missing, that's a problem. We know the Secret Service deleted those text messages. Uh-oh. We know the J6 committee seems like they deleted some evidence. Uh-oh. Many other government agencies may have information favorable to the defense as well. Wonder what happened to that. The government cannot pick and choose what sources of information are important to the determination of this matter. Justice requires that the defense be accorded the time to consider, request, and review all information material to the charges. And Your Honor, as the court stated in August 11th in our hearing, and as the government then agreed, this case should proceed in the normal course that our justice system prescribes. As explained above, the normal course for a complex, document-intensive case like this is not to rush to trial, but a measured schedule that preserves the defendant's right to discovery and the right to raise motions. They say, indeed, the median time from commencement to termination for a jury-tried Section 371 charge is 29.4 months. Many times it's longer, many times longer than the government's proposed schedule. And this reflects only the median, meaning half of those cases take even more time based on their individual circumstances. 29.4 months, the median. Some go faster, some go longer. Likewise, the court regularly allows far more time than the government proposes. Even in cases involving January 6th, you've done other cases where you've given us a lot more time. In other words, ordinary order then, Judge. We're not asking for anything special. We're not asking for anything crazy. We just want the ordinary order of court. That's it. Is adherence to the Constitution and the Speedy Trial Act, together with their assurances of fair and just criminal trials, regardless of the government's ill-placed desire to hurry this case to conclusion. And do you notice something we have not heard one time yet throughout this entire document? Election. Nothing. Nothing about election at all. No, he's in the middle of well, we have seen the campaign stuff, right? He's being prosecuted by his political opponent, but not like he's not a justification for postponement because of the election. In other words, don't continue it because the primaries are in January and that the election is in November. Nothing as a date there. It's only based on the amount of discovery, really, and the novel issues of law. They say that CIPA, the Classified Information Act, also controls some information in this case. These delays can be extensive. The government recently explained that they are unaware of any case with classified discovery that went to trial in less than 6 months. Court said, can you point, Mr. Prosecutor, to other cases involving classified information that have gone to trial following production of discovery in less than 6 months? He said, oh, so going to trial in less than 6 months? No, haven't seen that. But in this case, they want to do it in 4. Trump's defense says this case will be no different. The government acknowledges even uncomplicated CIPA cases involving very small numbers of documents with no substantive pretrial motions take a minimum of 8 months. It is therefore puzzling that the government would propose a trial date that the CIPA process cannot accommodate. We've got classified documents. There's a discovery process to get them. It takes longer than 4 months to do that. Our proposed schedule, conversely, accounts for CIPA and other issues that are going to pop up. They say another key factor in setting any trial date is the detention status of the defendant. So if you're in custody, the defense wants to go to trial quickly to get you out of custody. But Trump is not in custody here. There's no reason that this court should place the government's desire for a headline ahead of the interest of any detained defendant in this district who is awaiting trial, right? There are other people who are in custody who should go first. We don't need to rush this thing. Mr. Bratt previously led the DOJ's counterintelligence entity. He should know better. He's got, quote, extensive experience. He should know better, Judge. This is saying that Bratt is being a little dishonest here. He's being underhanded. He should know better, Judge. He's asking you to schedule a trial before he can even comply with the CIPA rules in most cases. The government's proposal also conflicts with other cases. Obviously, they are playing lawfare against Trump. And so here's the list. Other cases. If they want to schedule this thing for December and January, that's a conflict. Got a civil case in New York. 6-week trial beginning October this year. Another civil case, SDNY. 2-week trial, January 15th. Another criminal case, 5-week trial, scheduled by Alvin Bragg, New York. Big Fani Willis in Georgia has requested a March 4th trial date. That's also nuts. That will never, ever happen. A criminal case in the Southern District, because her case is basically an analog of this case. It kind of mirrors the January 6th case. I don't even know how many documents she's got, but it's probably millions. A criminal case in the Southern District of Florida also prosecuted by special counsel and scheduled a 5-week trial in Florida. That's the documents case. So they say President Trump must prepare for each of these trials in the coming months. All are independently complex. All will require substantial work to defend. Several will likely require Trump's presence at some or all of the trial proceedings, and beyond trial, these cases will include numerous pre- and post-trial hearings that will invariably conflict with the government's proposed trial calendar here. As one example, a pretrial hearing in the special counsel's Southern District of Florida prosecution is scheduled for December 11th, same day that they want jury selection to begin here. They say, Your Honor, without question, President Trump's obligations to diligently prepare for this case does not end because of other pending matters. We're not saying that. We know this, he's being very, very accommodating to this judge's request. This is Judge Chutkan, and she said, I don't care if he's running for office, and I don't care about any other things. He's here in my courtroom. He's saying, I know, Your Honor, like we're here, making sure you know that. Hasn't even mentioned primary dates or November. However, the court may and should consider the practical effect of these parallel prosecutions and what they are going to do to Trump's ability to meet the extraordinarily brief deadlines that the government is proposing. Once again, the government's proposed schedule does not address these significant concerns. Our schedule resolves them, so you should adopt it. In conclusion, the proposed schedule appropriately balances President Trump's constitutional and statutory rights to counsel and fair trial with the public's need for promptness. The schedule is consistent with the ordinary order, resolves the conflicts presented by SEPA and other pending prosecutions, and so, Your Honor, accordingly, the court should determine that the ends of justice outweigh the interest of the public and Donald Trump that he has in a speedy trial, adopt the proposed schedule, and exclude time, meaning don't count all of the time between today and April 1st, 2026, against Trump. Respectfully submitted by Gregory Singer. And can we just pause for a moment and shout out Gregory M. Singer on a brilliant motion. Shout out to the rest of the team there. Also at Lauro and Singer, along with Blanche Law Firm, out of Tampa and New York, doing some excellent work there. What an outstanding motion. And they left out, a lot of the same election arguments that he's running for president. And this is a political prosecution in the middle of a campaign, and we need to postpone this until after the campaign. You didn't hear about any of that at all. It was just straight to the facts. And they have boxed the DOJ in here in a very brilliant way. They dropped 11.5 million documents in initial discovery, and that is 8 Washington monuments. 8! Full of documents, okay, physical documents. And now they're going to have to eat that. So that's going to be very interesting. Now, very excited about that, and I think that might have something to do with what Trump is doing here. He has canceled his voter presentation, probably because they have an extremely strong case here that there are discovery violations and that they have the due process and equal protection obligations to postpone this thing far. So he's saying, all right, strategy's changing a little bit, no problem. Says rather than releasing the report on the rigged and stolen Georgia 2020 election on this Monday, my lawyers would prefer putting this, I believe, irrefutable and overwhelming evidence of election fraud and irregularities in formal legal filings as we fight to dismiss this disgraceful indictment by a publicity and campaign finance seeking DA who sadly presides over a record-breaking murder and violent crime area called Atlanta. Therefore, the news conference is no longer necessary. Probably a good decision legally. Of course, I kind of wanted to see, just for the morbid curiosity, the battle between the courts and free speech, protecting the judicial integrity, the process, blah, 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 and Trump's ability to speak out about a corrupt process that really doesn't have any integrity in the first place. So I would have loved to see that. We might still see that. Hang tight to that. It might come down the line at another time. But we are turning to Rudy. Rudy, of course, is a co-defendant of Donald Trump who has been charged with a crime in the same Georgia case. And he is out here roasting Big Fani. This clip came over from Patriots Are in Control. Says from Rudy, says that he's roasting Big Fani on his show. Here's what he said.
You don't think we could get doctors to say he's not mentally capable of doing the job? You could get a lot of doctors as long as you offer them protection against being prosecuted by Fani Willis.
Yeah, Fani.
She'd probably do a RICO case against the doctors. She doesn't even know. I don't even think she knows what the RICO statute is. You know how many mistakes she made in that indictment? Do you know how she made it so much more possible to remove the case? Because she's so damn stupid, she didn't bother to read 28 U.S.C. 1442.
We'll take a look at it.
I had that in my file for 4 weeks. Said nothing about it because I didn't want to alert her. Because she could have tailored the indictment to make it more difficult to remove the case. One example, I'll just give you one. I mean, it's over now, so it doesn't matter. She didn't have to put in all those other places. The minute she puts in all those other places, it becomes more of a federal case. Makes it an easier argument. Now, not critical. Probably could have won the argument anyway. She just made it easier. The job of a lawyer is to help your client, not to hurt your client. And the client's objective here is to unfairly prosecute and convict innocent men and women. Well, she made it more difficult to successfully prosecute innocent men and women.
Good.
And it's an outrage that the left wing in this country and the media and what stands and watches this, watches the former president of the United States have to go into a jail that the federal government finds inhumane and indecent. Of course, it's a crooked city. Is there anybody with common sense in Washington? And is there anybody with guts?
Not really, not in Washington. But so that's Rudy. And he makes a good point, right? 28 U.S. Code 1442. This is the same statute that Mark Meadows is referencing for his federal removal. And we'll, of course, take a look at the Mark Meadows removal, the order from the judge granting the removal hearing in another segment. But this is the summation of the code that Rudy's referencing. 28 U.S. Code 1442, federal officers, when they are sued or prosecuted. We've got this, a civil action, forget that, but a criminal prosecution, which is currently happening out of Georgia, that is commenced in a state court, like Big Fani's, and that is directed against anybody who's one of the following, may be removed by them to the district court, the federal court, from the state court up into the feds, for the district and the division embracing the place where it is pending. It says the United States, if they're the subject, or any agency thereof, or any officer, or any person acting under that officer, right, of the United States in an individual or official capacity relating to under color of such office, the title authority, if they're acting under the president, who is the executive officer of the United States, they have the right to remove the case from Big Fani's court to the federal level. And so the cases are just looking brutal. And Trump and his defense are filing some good substantive motions. And even Bill Barr is agreeing that some of this case doesn't look so good. Here is what he said.
Meanwhile, the focus on the former president's legal cases, there are 4 big ones involving 91 charges, again, across 4 humongous criminal cases that could go on for quite some time, especially if the Trump lawyers have their way with trying to push.
All right, weirdo.
I'm not happy with the Georgia case. I think it's much too sweeping, much too broad, excessive case that is make it look like people are piling on and being excessive to Trump and feed the narrative that he's being victimized here.
He is.
And I also think there's merit in the
Isn't
point.
this strange? He says the weirdest things. He's like, this case is so garbage and it's overbroad and it feeds the narrative that he's being victimized. And you're like, Bill, you just described him literally being victimized. Are we nuts? He just described an overbroad prosecution that is just not very valid and is upset that it feeds the narrative. But is he concerned about the actual prosecution?
In March, what the prosecutor is looking to do. It's right around Super Tuesday, but besides that, it's not nearly enough time. What do you think?
Well, I'm not happy with the Georgia case. I think it's much too sweeping, much too broad, excessive case that is make it look like people are piling on and being excessive to Trump and feed the narrative that he's being victimized here. And I also think there's merit in the point that this is a case that I don't think is going to be triable before the election. It's just too sprawling.
Can any of them be tried before the election?
I think the two federal cases will be tried, and they are. I think the responsible cases. They're far more focused.
Not with the 11 million documents there, Bill.
Will be tried before. The New York case is, obviously a political hit job, and in my opinion, it's a joke.
On his business dealings and everything.
Right.
Did you hear that? There's another hit job and another joke, but also there's a ridiculous narrative that Trump is being victimized. That's two. He just gave us two examples of himself where Trump is the victim of insane prosecutions. But that dang narrative, very pesky. Don't know where that came from.
It was the payoff, the hush money, and I think at the end of the day, that may not be tried. I think it could just be pushed out because I think Bragg would be worried about actually bringing it to trial.
But even in the case of the one that you argue could be, that is Jack Smith's trial, he wants to get going, in January. I mean, right before the Iowa caucuses. I mean, should they be weighing the timing of either Super Tuesday in the case of the Georgia one or the Iowa caucuses in the case of Jack Smith's one? What?
It's all about the elections.
To some degree, they might accommodate, a few days here and there, but I don't think that should govern the schedule for pursuing these cases. You don't get immunity for 2 years in the run-up to an election just by saying, hey, I'm a candidate, you can't try me. These investigations have been going on for a while. Everyone knew about them even before he announced his candidacy. So if there's a chance to get it resolved before the election, it should be, because the American people should know these are crimes that involve, or potential crimes that involve moral turpitude.
Now, busted, Bill. So, he's just in his own little bizarre world. Very strange state of affairs with that guy. But he agrees Georgia's garbage, New York's garbage, but Trump is still making this up like he's the victim of political prosecutions. I think he's wrong. I don't think any of these trials will go. Does he know that there's 11 million pages of documents out there? Not so sure he does. Of course, we'll continue to cover this amazing scheduling memo from Trump's team. We're going to continue to cover, my friends. Thank you for subscribing and following along as we do. Now, let's jump in to the removal hearing. Mark Meadows, co-defendant in a prosecution against Donald Trump, has successfully gotten his removal request scheduled in federal courts. Good news. We know that Trump, Meadows, Giuliani, and many others are being prosecuted by Big Fani Willis out of Georgia. State court. Question is, can Trump, Meadows, Giuliani, and others remove the case from state court up into federal court so they've got a better jurisdiction? They've got a federal judge rather than a state judge. So this becomes a federal case, not a state claim. And arguably, Trump could get a better judge. You could say it's a federal claim now. Maybe Trump can walk right in and pardon himself from this. All sorts of different tactics that this could go and different routes this could go. But let's take a look at the order from the judge. This is what the court has ruled. And we expect ourselves to see a similar filing from Donald Trump. It's 11 pages. We'll go through it relatively quickly because a lot of this is technical stuff. But they say the matter appears before the court following Mark Meadows' notice of removal under that statute, 28 U.S. Code 1442. The court enters the order following, the satisfaction of the statutory requirements for state criminal prosecutions being removed. The court says, in summary, that the summary remand is not required. In other words, this case can stay here for the meantime. Remember, we've gone through this once before here. Donald Trump tried the same thing in the Alvin Bragg prosecution out of New York. He said, I was running for president. The New York allegations stem from my conduct that was running for president. Therefore, it's a federal issue. I was a federal officer. It should be removed. The court just said no. We didn't have a hearing. We didn't have anything. The judge just wrote a motion. Nope, rejected. I don't find that you were in the office of the presidency at the time, or this was contemplated for that purpose, these loans or these payments over to Cohen, and so rejected it. We are past that hurdle now. We are now in federal court. They say, on August 14th, the grand jury, Fulton County, returned an indictment against Meadows. 18 other co-defendants, of course, Trump is included. The indictment says Meadows and his actions related to Georgia violated Georgia criminal statutes. Meadows served as the White House chief of staff under Trump for a while. He's now included in a RICO claim. It alleges the following as predicate acts in support of RICO. One, that he met with Trump and Michigan officials. Another one, he messaged a representative. He and John McKenty put together a memo that they say is disrupting or delaying Congress. He was trying to observe in Georgia and was physically prohibited from observing. He arranged a phone call between Trump and investigator in Georgia, Francis Watson. He messaged an investigator. He solicited, along with Trump, Brad Raffensperger. They say to violate his oath, right? This is from Big Fani's claim. And so on. The indictment further charges that Meadows solicited a violation of public oath. They say, all right, Meadows filed this removal to the federal court. He says federal jurisdiction exists because I'm a federal officer. My official duties were arranging meetings, communicating with state lawmakers, and I attempted to go audit Georgia's election so I could report to the president as the chief of staff. With the background in mind, the court says, the court now determines, we ask ourselves, now that we know all this, whether it clearly lacks jurisdiction over this case and whether this case has to be booted back down to the state court. Can the feds keep it, or is this for the Fannies? And again, this is not a final determination. This is only to schedule a hearing to make arguments on this case, because Fani, we haven't heard from Fani yet. She hasn't submitted anything. Mark Meadows submitted this, and so on its face, they say, all right, Mark, you make a convincing argument. So now we're going to have Fani come in and say, no, this is why it has to go back down. But we never got there in New York. So the legal standards, they say federal courts are courts of limited jurisdiction, only the power authorized by statute. One statute says the following, and we'll fast forward through a lot of the technical codes. Analysis, they say according to all those rules, the court first determines that Meadows' removal does meet the requirements of the law. Here's why. Meadows removed this action 1 day after the indictment, so he didn't wait too long. Timing requirements have been met. The removal contains the grounds for removal, the basis for federal jurisdiction, and so he checked the other boxes. The court now, we must look at whether the removal filed, if it clearly appears that the removal should not be permitted. Is there anything that says it should not come in? They say, here, the court determines that the notice of removal and the attached indictment, so Mark's filing and the indictment, are sufficient to show that summary remand, a rejection, is not clearly required. In other words, it is not immediately apparent on the face of the documents that we must reject this. The notice of removal indicates that Meadows held the role of the chief of staff for a while. He also submits he was acting in his capacity when all of the criminal allegations occurred. He asserts that his defense to these criminal charges arise under federal law and under the Supremacy Clause of the federal Constitution. So accordingly, the federal court determines that Meadows' notice of removal is sufficient to withstand the remand. Withstand the remand. The court emphasizes that this order offers no opinion on the court's ultimate determination on this. We're not saying whether he's immune or not. We just say that the court is going to make its final determination on these matters once it's been completely argued, once these matters are briefed and ripe for the court's review. If he's going to say, I've got federal immunity here, we need a federal court to deal with this. So to reiterate, the judge is being very clear. This order's limited conclusion is that the court, based solely on the facts here, does not clearly lack subject matter jurisdiction over this, and therefore the court will proceed with an evidentiary hearing pursuant to the code, going to the next step, which is good. Like, you can expect to see other defendants who were federal officials file this. In conclusion, they say, for the foregoing reasons, the court concludes that the face of the notice removal do not clearly that we have to reject this. No opinion about the other defenses. So therefore, we order that the parties participate, including Big Fani. You got to show up to federal court concerning the notice of removal of the indictment against Mark Meadows. So get your butt over there, prosecutor. Monday, August 28th, 10 a.m. Courtroom 1907, Atlanta, Georgia. The court orders that defendant Meadows immediately serve the Fulton District Attorney Fani with a copy of this notice and a copy of this order. So now Meadows is doing the serving. How's that feel, Fani? She may submit a written response to this or show up in court. If she wants to challenge this, August 23rd, and her response must be no longer than 25 pages. Signed by the Honorable Steve C. Jones. So that's very interesting news. So Big Fani's going to have to show up there and respond to this. Now you notice something, that they said that they needed to serve her with a copy of this so that she knows to appear. But something interesting happened. Mark Meadows and his team, they filed a notice regarding service. This is weird. Why would they have to file this? Shouldn't they just serve her and just say, here's our affidavit of service? What's the notice about? Let's read. Says, hey, Mark Meadows, by his lawyer, hereby provides notice regarding compliance with your order to serve Big Fani with this. Pursuant to the order, I mean, she's got an office. She's like in Georgia. Like, just walk into the office and serve her with the document, right? Like, how hard can this be? She's the biggest Fani in Georgia, literally. She's the district attorney of Fulton County. Huge. Can't miss her. Pursuant to the order, Mark Meadows and the lawyers attempted personal service of the notice of removal and the order on Fulton County District Attorney's office earlier the day. That's Willis's office. However, Meadows' process server was told by the receptionist that there was no one in the office that can accept service and to try back on Monday. What? Big Fani won't even accept service from a federal court at her in a case that she's working on? I mean, from one of her defendants. This is Mark Meadows, a defendant. In her case, showed up to the county office. So they say that they're rejecting our service, judge. I don't know what they're doing. Just let you know. In light of the foregoing, this afternoon, we sent an email to Big Fani and to Deputy Fulton County District Attorney Wooten, who had also entered an appearance in this action earlier on the day. We attached the notice of the order and we request that their office accept service via email. So we'll just email it to them. Can you guys just accept service? Something weird happened. We showed up and you rejected us. How about you just accept us? Now, an email, certainly they both got it. Big Fani, this is her biggest case in history. As of the time of this filing, Mark Meadows has not received any response to this request. And defendant will attempt personal service again tomorrow and continue his best efforts to effectuate service on Big Fani Willis. Why is she hiding? What's she hiding from? Defendant also notes that despite having yet to been unable to personally serve the order, the Fulton County DA's office has already received notice of this action and the upcoming hearing. In addition to the email sent by our lawyers earlier today, counsel previously provided notice of this removal action to Willis, Wooten, and 3 other attorneys via email back a few days ago. Ms. Willis promptly responded to this email, confirming that the email from Meadows' attorney was received. We know Willis was listed as the attorney of record on the docket and received the notice as well from ECF, which is electronic court filing. Submitted by counsel for Mark Meadows, Joseph Englert, out of Atlanta, Georgia. Shout out to Joseph Englert. August 17, 2018. What's going on there with Big Fani? What's she running away from? Oh, she's got a notice. She's got an order to be served from a federal court, and she's hiding from it. Very strange. Now, something else is interesting here. So there was another filing from the Meadows defense team, and they're holding firm to this August date. They say, Your Honor, earlier today, Meadows, in our defense, we know that counsel for another defendant that is named as a co-defendant in Georgia, he informed the court by email, and I don't know who this is, that he intends to file a forthcoming notice of removal as well. So this judge is saying, oh, we're going to have, there's 18, 19 co-defendants here, so we might have more of these. And they suggested via email that they postpone Mark Meadows' hearing. Okay, Mark Meadows has his hearing on the 28th. They're saying we better consolidate all of these removal requests and let's just do it together. But Meadows says, no. How about no? Meadows opposes any delay of the August 28th hearing. As this court has noted, Mr. Meadows has a right to prompt hearing under the removal statute, and we've scheduled the hearing accordingly. Moreover, Mr. Meadows has articulated grounds for seeking removal unique to Mr. Meadows that should be considered unencumbered by different issues potentially raised by different defendants. So they can make their claims, but don't batch us and lump us up with them. Accordingly, Mr. Meadows respectfully submits that the court hearing should proceed as planned. Signed again by Joseph Englert. And this is going to be interesting. And we've got all these different co-defendants all crashing into one another. And the courts are going to have to untangle them. Big Fani got the whole thing just jumbled up. It's a messy ball of yarn. Now, John Ratcliffe, who used to be Trump's director of national intelligence, had some comments about this. He says, all said and done, what we see here is this is just an operation to go after Trump. All said and done. They've been working on this for years. Here it is.
Oh, Maria, I don't think it's that they're ignoring it. I think it's that they're scared. Look, you have to keep in mind that they're all co-conspirators in this. They're all complicit in this.
Talking about
what I mean by that is all of this stuff wasn't. It was the fact that the mainstream media went with all of the things like the Hunter Biden laptop as Russian disinformation. They promoted the 51 intelligence officials that were lying. They promoted the Russia collusion story. All of these things, and folks at the Department of Justice and the FBI, they lied to get FISA warrants to spy on the Trump campaign. So they're all. They were all part of this, and they're all complicit in this, and there's so much at stake. And if it unravels, it's not just political folks that will take a fall on this. It's the American people will see it for what it is. Now, so having said that, these are the challenges that President Trump continues to face. With these charges and the trial dates that are coming up. The thing that I would point out to people here is that Donald Trump didn't run for president to run for re-election as president to avoid political charges, as some people are saying. You got to remember, he announced he was a candidate first. He became the front runner first. All of these charges in Georgia, in New York, both Jack Smith cases and the federal cases, they decided to bring charges after Donald Trump became the leading contender in the Republican nomination, which just really underscores why this all continues to be political and why it's all directed at trying to stop him from being reelected.
Yeah, we often forget about that. I mean, they had years to bring these charges. He announced, then they said, time to appoint a special counsel. And the whole operation launched into effect. 4 prosecutions, 4.5 months, all the trials they want right before trial, right before the elections. It's an obvious operation, fully intending to stop Trump. But fortunately, we're seeing some pretty interesting filings here because it feels like in many of these cases, the prosecutors bit off more than they can chew. And we'll see what the judges do with these filings as we continue to cover. All right, my friends, now we've got one final segment here, and this guy is just something else. So let's just get right to it. Hunter Biden's lawyer rages on Morning Joe with Joe Brzezinski, and he is not a very friendly guy, even to a friendly, in the Joe and Brzezinski show. We know that they're rabid anti-Trumpers. We know that Hunter's lawyers and many people in the media are constantly pointing to Trump, Trump, Trump every time anybody says anything about Biden or Hunter. And this was an interesting exchange because these are people who should be on the same side. And we watch what happens as Morning Joe interviews Abe Lowell, Hunter's lawyer.
Federal judge in Delaware has dismissed misdemeanor tax charges against Hunter Biden. The decision had been expected following last month's failed plea agreement between federal prosecutors and the president's son. Special counsel David Weiss is expected to refile the charges or bring new ones against Hunter Biden in California or Washington, D.C. With us now, counsel to Hunter Biden attorney Abby Lowell. Abby, thank you so much for being with us. What in the world happened? That was a mess. So we're about to get a deal.
What happened?
Suddenly it blows apart. Why?
Well, if you were in court or if you've read the reports, the principal issue, as you could see and hear, was a misunderstanding or disagreement between the two sides as to what the deal covered in terms of future possibilities. And so, Joe, there are three possibilities to why it broke down. The first possibility is that the prosecutors who wrote it, it's their document, didn't understand what they were writing and therefore weren't sure why it would be that we would want a firm commitment that this was the end of the investigation. The second possibility is that they actually did know but misstated to us that they had an agreement. Or the third is that they hoped nobody would understand and that it wouldn't be revealed that that's what they intended. And then they kind of dissembled in the courtroom. So you could pick that. But I can help you answer that three possibilities with the following question. What group of competent attorneys on the defense side would allow their client to plead to a misdemeanor on a Monday, knowing that the government could prosecute their client on a Wednesday for a felony? It would never happen.
So did the prosecutors act in bad faith? And if they did, why?
Well, as I said, you'll have to talk to them. I can give you the theoretical three possibilities. I can tell you that defense attorneys wouldn't do what they think happened. And so now you have to decide. But I don't know what they did.
I do. Everybody knows what they did. They all had some gray area in the plea deal and in the diversion agreement. They all had an unwritten deal, an unspoken agreement, and the judge called them out on it. They wanted to get it through because if they could get it through, then there was if they could just get the signatures on it and just get started, and this gray area wasn't exposed, it would have allowed them, if anything happened, to point right back to that plea deal and allege immunity regardless. They just had to get it done right past the gate. If they could squeeze it through, they were golden for the future. And the judge just happened to call them out, read the both documents. Says, how does this work? And how does this work? And you guys want me to do this and do this? A lot of other judges may not have caught all of that. May have just signed off on it and turned it in. And if that would have happened, there would not have been a special counsel. They all were acting in a corrupt fashion, and the judge just asked them to explain. Both sides were in on it. It's not like these defense attorneys knew that there was this, couldn't recognize that there was this gray area. They knew it was there. It was all structured by design.
But I do know that there's only three possibilities.
Yeah, so Chairman Comer keeps going after Hunter Biden, and I must say he keeps embarrassing himself time and again. I won't even go through all of the missteps he's made, but I am wondering, have you...
What do you mean, like meeting with the whistleblowers, exposing the Biden crime family, all their bank records, hundreds of SARs, Gal Luft, all these people? What are you talking about?
You all considered having Hunter Biden testify in Congress before that committee?
I think that's just premature, but I think as you pointed out before your break and what you just said now, you have to have a serious congressional proceeding in order to consider having somebody like your client come. And there's been nothing serious about this set of proceedings. This is a set of Republican chair people who have done the least the following. They basically started by admitting that the whole point of their proceeding was, to use his phrase, move the political needle. Since then, they've basically said the reason the United States is helping Ukraine because of the bribes that occurred between the two. Then they have said that the reason that the Titan submarine news was suppressed was to cover up for the deal that was going to be announced for Hunter. Marjorie Taylor Greene used an oversight hearing in order to show naked photos of our client. Comer has basically just been bragging that he's the one, to use his phrase, who shoved the plea bargain up the you-know-what of the Justice Department. There have been allegations that there was a whistleblower, which turns out to be, first they said the guy was missing, and then it turns out that he is a fugitive and that he's involved in obstruction and being a foreign agent. With that...
That's Gal Luft, the same guy that the same DOJ is charging because he called them to blow the whistle on the Biden crime family. It's all part of the same corruption deal.
panoply and laundry list of the things that these members of Congress have done, until they show that they have a serious intent, are operating within the rules, and have a proper legislative purpose, nobody would go before them.
Well, just to add a little meat on the bone there of their so-called informant, that agent of Communist China also tried to smuggle Iranian oil illegally to the Communist Chinese Party. So, yeah, they have a rich cast of characters. I'm curious, they're obsessed with connecting Joe Biden with some of these business deals. Is Devin Archer correct that Joe Biden got on the phone in some of these meetings with Hunter Biden and the business associates overseas?
I think the better answer to that question is everybody, I think, now knows that President Biden speaks to his children and his grandchildren frequently, almost every day.
Almost every day. Put a pin in that. Almost every day. They speak almost every day. They've been doing that for years.
Cases. And I don't think it's unusual, whether it's at a family gathering or perhaps when Hunter was at a business meeting, that would happen. And if there was any conversation, as is Mr. Archer's point, it was like chit-chat friendly, like, how's the weather? So it had nothing to do. Look, one of the things Congress has done with all of their staff and all of their power and all of their gavels is to try to make a connection between the president and any business dealing of a private person called his son. They haven't been able to do that. And back to your other point, one thing people should understand, if they are paying attention, and I hope they are.
We are, yeah.
That in terms of the investigation at the Justice Department, what gets lost are the following two things. First, this was a Republican-started investigation run by a Republican U.S. attorney who had 5 years to look at every transaction that could possibly occur. And at the end of that, decided that the only two proper charges would be a failure to file misdemeanor and a diverted gun charge for when Hunter possessed a gun for 11 days, which was never loaded.
That all is a conclusion that people say is corrupted. What's the evidence of that? 2 IRS whistleblowers, Gary Shapley, Joseph Ziegler, and an unnamed FBI supervisory special agent who confirms and corroborates their statements. So that's the point. Like, they come out and they say, oh, the conclusion says there was only these 2 things. No, that's the corrupt bargain that was the excrement from David Weiss's inquiry.
And so after 5 years with no motive to turn the other way to any wrongdoing, that's what they thought was appropriate. People seem to forget the other important point, that when they came to that conclusion, that was after Hunter had already paid his taxes 2 years before the events occurred this last year. And that gets lost in the wash as well.
Well, what he's talking about is that, Hunter, has these very harsh charges that are brought upon him, and he neglects that there were dramatically more serious crimes that he could be charged with, hundreds of SARs and all of the other things. And he's still saying that this is just too much. Hunter should have not even been charged for this because he already paid the taxes. Well, the bigger crime is, and first of all, that's not even true, right? He had other statute of limitations expire for other criminal charges in 2014 and others.
How many people actually get charged and convicted for these misdemeanor tax charges? Would that have happened if his last name were something other than Biden?
A point on this, if that was the original charge, if your original crime was what Hunter is pleading to, they probably would give you a diversion deal. They'd give you some of an offer. So you wouldn't be charged with that crime and then also plead to that crime. You would be charged and then diverted into something lower. It's it's a deal, right? You get a high-level DUI, you negotiate it down to a reckless driving, whatever. Same thing here. So the answer is that, yeah, probably a lot of people are not originally charged and convicted on that level because they're diverted into a better deal. Hunter got from aggravated murder. Hunter got a DUI with kids in the car, third offense, blood alcohol content, let's say 0.35. Also cocaine, we'll call methamphetamines, heroin, and other things in his blood system. Crashed into a building, killed somebody, fire hydrants going off. Kids are screaming all over the place. It's madness. That's his criminal charge, and then they divert it all the way down. He gets a plea deal. Speeding ticket. 56 and a 35. Civil offense, 3 points on your license. Oh, man. Yeah, so that's like what's happening here. And then they're saying, well, that, I mean, nobody gets speeding tickets for 56 and a 35 on that road. Like, nobody gets that. That's really harsh.
Well, here's the statistics that I think you're raising, which is the following. There are millions, literally millions of Americans who file their taxes late or don't file them at all. And they don't get charged with criminal offenses.
That's not what Hunter did. Hunter structured multiple LLCs, embezzled millions of, tens of millions of dollars. He didn't file his taxes late.
Didn't get the opportunity to fix it by paying a fine and paying interest. There have been those who have said that Hunter Biden has been given a favorable deal by the prosecutors. It is very likely that if his name wasn't Biden, it could have come out different. But I want to say that when it was brought to his attention and it was a way to resolve the issues, Hunter was very willing to accept responsibility for the mistake he made in late filing. It doesn't cover the fact that so many other people would do that and don't get charged criminally. But that doesn't undermine his desire to both put this behind him and to accept proper responsibility.
I'm sure.
But for those who would say, oh, this was some sort of sweetheart deal, they should really look at the statistics and see how he was charged when others would not be.
Yeah, we would like to see the statistics. Yeah, how many other people are charged with structuring LLCs and hiding millions and millions of dollars in the way that he did with, the SARS reports and the structuring of the Owasco, Rosemont Bohai Harvest, all of them. They would be charged. They would be in prison. But he never even got those. Late filing.
And we've been talking this past week about Steve Ratner came on, showed charts. Jared Kushner ended up getting about $3 billion for his fund. Only 1% of that from American investors, most of it coming from Saudi Arabia. Unprecedented. And of course, we've been drawing the connection to the fact that he worked in the White House, and that's one of the reasons he got that money, and perhaps the only reason he got that money. $7 million ain't $3 billion.
You see how that works? So before he asks him a hard question about $7 million, he's got to pre-frame this question. Trump's really bad. Everybody in Trump's life is the worst. Jared Kushner, blah, blah, blah. But I also need to ask you about this $7 million. So can you tell me about that?
At the same time, I think Americans are asking, what did Hunter Biden think he was getting that $7 million for? Why would he be getting paid so much money?
Here we go.
All right, well, stop with your $7 million and talk about how many years that Hunter has been in business and what happened to each of those specific years. When you say it that way, people think that somebody just sent him a check for $7 million on April the 1st.
No, but help me out here again. And I'm glad you're here to actually break this down. Obviously, Jared raised his $3 billion very quickly.
Yeah,
we have numbers being thrown around. The $7 million is actually not what Comer's saying. Comer has a much higher, much more elevated number. I guess the Washington Post reported it was $7 million. What's the $7 million over, and how many countries did it come from?
Well, okay. So first of all, it's much more complicated than to say it comes from countries. Yeah. There are joint ventures between American entities and in one or two occasions, a potential foreign entity to create the possibility of jobs and energy in the United States.
Jobs
That's
and energy.
Too complicated to try to explain, but I can answer the question that you asked in the following way. Over the time that he was in business, this is, again, something that people ought to pay attention to. Hunter Biden went to Georgetown University, went to Yale Law School, was on the board of directors of a bank, was on the board of directors of Amtrak, is somebody who went and worked in an international law firm. People seem to forget that this is not the person who's simply out there having people write checks for no reason. He's a capable, educated, experienced person.
Drug addict, crackhead.
If Congress wants to start saying, wait, does he get opportunities because his last name is Biden? They should look to themselves. I mean, Senator Joe Manchin's wife is on a commission in West Virginia where Congress had provided an enormous amount of funds. There is Congressperson Boebert, who has a spouse that works in the consulting business. If you start dissecting people who have the ability to use their connections and their name in order to get an opportunity, then okay, but then what's good for the goose, good for the gander? Congress should look at their own. People have been doing this for millennia. Maybe it's not fair to us who don't have the name, but that's what happens. And the most important point is that it's not improper and it's not illegal. And the thing that's different, and you just said it again, is that Hunter Biden has never been in a family business like the Trump kids, and he's never acted as an advisor to the president in the White House, using both of those in order to then conduct business. That's a fundamental difference that also ought to be remembered.
Yeah, you know, he's got the Biden name. We don't. Good for them. Not so good for us. Not illegal. The fact that they're just grifting millions of dollars, exchanging foreign policy decisions for $83,000 a month from Burisma in exchange for firing a prosecutor. None of that's that big of a deal, okay? You wish you were a Biden. This guy makes you sick. All right, so we'll leave him there. Now, that's the lawyer, okay? That's the Hunter lawyer. And they have, in the court in Delaware, filed to dismiss the tax charges. And I'll briefly share with you exactly what that looks like. You see, this is the order that is dismissing the tax charge. Now, this is been dismissed without prejudice, which means they can refile it. And the government has indicated that they will refile it. They say that in the motion. The judge is including that as part of her finding. It says the government has said venue is improper. Venue is supposed to be waived pursuant to the plea deal. There is no plea deal. There's no waiver of venue. Means we're in the wrong court. Means we got to go to a different court. So the government has moved to voluntarily dismiss the information without prejudice so that the United States can bring charges in another venue. So the government requested it. Hunter's lawyers agreed to it. Judge Mary Ellen Norica and ordered it, dismissed. Now, my question on this, is the government actually going to bring the charges back at a later date? We know there has been a special counsel that's been appointed now. And so how long before the charges get resubmitted in another jurisdiction? We'll see, if ever. Now, there was another filing. This also came from the judge. Says that Hunter moved to seal certain exhibits. You remember this. This was a battle where Hunter's defense team allegedly tried to remove the amicus filing from the House Ways and Means Committee. They submitted this big document. Hunter's team apparently called the clerk of the court, tried to get it removed off the docket. Representative Smith opposes the motion to seal. They wanted to seal it. The court says there is a presumptive right of public access to this stuff. Sorry, Hunter. There is a strong presumption of openness. A party seeking to overcome the presumption of access bears the burden showing that secrecy outweighs the presumption of openness. To overcome that presumption, you got to find some strong findings, specific findings on the record about the effects of disclosure. They say broad allegations of harm, not sufficient enough. And the representative says that these have been public for a long time. So the judge rules, because Hunter Biden failed to make any showing of specific harm from having these documents be public and has failed to address the documents sought to be sealed on an individual basis, it is hereby ordered that Hunter Biden's motion to seal is denied. The materials by Representative Smith, the amicus, shall be unsealed in their entirety, which is all good news. Those were already publicly available. But Hunter just wants to keep this stuff sealed. The judge obviously rejected that request. So here is James Comer responding to some of this, explaining what he has done to go continue his investigation into the Biden crime family. One of his recent releases was the fact that Joe is using pseudonyms to conduct his business.
Giving you the money, is that the same day?
That's it.
And that would be the day. Now, as a result of that firing, did his son financially and get paid on the Burisma board for a job at a time he was a drug addict and a time that he was also admitted in his own words?
It's all a pattern here, Sean. This is something we've been talking about for a long time. The Democrats and their friends in the media try to say there's no connection to Joe Biden. Every day there's more connections. And I think these emails today are consistent with the timeline that shows exactly what the real quid pro quo was in Ukraine. It was Joe Biden, not Donald Trump.
The WhatsApp message is very revealing. I'm sitting here with my father. Why didn't you keep your commitment? We expect a call from you. Wasn't that sent to a oil executive with CEFC, the Chinese energy giant?
Yes, it was. And remember, that WhatsApp message was produced by the IRS whistleblowers. This was the IRS International Tax Crimes Team. This was the A team investigating all these suspicious wires, the suspicious activity that the Bidens were getting from foreign nationals around the world while Joe Biden was sitting vice president influencing foreign policy. That's why the whistleblowers were so frustrated when they were told to stand down, because they said their investigation was clearly going straight to Joe Biden.
Let me ask you this, that 1023 form that the FBI desperately tried to keep from you, the one that used an FBI informant, and that informant was trusted by the FBI, but he had.
And see, you look at that 1023 form that alleged the bribery. It's consistent with what we've seen in Romania. It's consistent with the timeline that you and John Sullivan have documented on your show tonight. And I believe that one reason that Hunter was CC'd on those emails where Joe Biden was using a fake name is so Hunter could prove to the Ukrainian oligarch, look, help is on the way. Because we heard from
Robert
Devin Archer
L.
say
Peters.
that
Pseudonym Joe.
the owners of Burisma were squeezing Hunter Biden, saying we need help from Washington. Now, who do you think they were referring to when they were talking to Hunter Biden, who they've said was dumber than their dogs, who was a drug addict, who had no experience, that we need help from Washington? Who do you think they were talking about? And here we see now evidence that shows Joe Biden didn't have a wall between the government and his son's shady business dealings. He was copying him on foreign policy to let him know ahead of time, help is on the way. We're going to go in there and we're going to fire that prosecutor who's trying to bust you for corruption, son.
Amazing. So the pseudonyms and all of the different connections, the emails, I mean, they had to communicate, and obviously they were doing it in nefarious ways. Stuff was getting done. Feels like the dam is starting to break as these connections are being made. Jake Sullivan's having a rough time, probably been running around the alleys, the gutters, wherever Hunter Biden is, picking up the cocaine falling out of his pockets. Got asked a question about this. Says, hey, Mr. Jake, does the administration, the Biden administration, just as a reminder, Jake Sullivan went to Oxford, okay, very smart guy, evidently. And he's also the National Security Advisor, which means national security and foreign affairs sort of matters, kind of within his jurisdiction. Question for Jake. Does the administration view the Hunter Biden investigation as legitimate? And is the administration concerned that Hunter Biden's ties to China pose a national security issue? Given the fact that, this is the National Security Advisor, Jake Sullivan, here's what he says about all of that. And he's having a rough morning or something. Here's what he looks like.
Republicans in the House Oversight Committee are currently investigating the Biden family's ties to foreign entities. They have specifically pointed to Hunter Biden's financial ties with China. Does the administration view this investigation as legitimate? And is the administration concerned that Hunter Biden's ties to China pose a national security issue?
I don't have any comment on that.
Republicans in the House.
What is all that education for if they can't even answer a simple question like that? Well, that's Jake Sullivan for you. So he's been in the government for quite a long time. That's who is leading us into national security, doing our advising. Now, what is interesting here is that the Democrats and many on the left, they want direct deposits and check slips and other receipts with Joe Biden's signature on it with a little heart and, sniffles or something on there. I don't know. But what about the fact that Joe Biden has been lying to us repeatedly in debate after debate, in appearance after appearance, lying directly to our faces? We know that he talks to Hunter all the time. They told us like once a day, regularly calls into business meetings and all of these things. But why did he tell us definitively that Hunter didn't make any money from these deals if we know that he did? Didn't Daddy know what Hunter was spending his money on? He didn't ask about other things other than the weather, like where'd you get that car that was apparently paid for by a foreign individual to the tune of $142,000 wired over and then wired to a car dealer? Dad didn't ask any of these questions every day they talked, and he in fact told us the opposite, that he was not getting paid specifically.
And Kristen, Glenn Kessler from the Washington Post had a fact check about Joe Biden from earlier this month, noting that Hunter Biden admitted in court in July that he was in fact paid substantial sums from Chinese companies. Kessler wrote, Hunter Biden reported nearly $2.4 million in income in 2017 and $2.2 million in income in 2018, most of which came from Chinese or Ukrainian interests. But this directly goes against what Joe Biden said in the debate in 2020 with Donald Trump. Take a listen.
My son has not made money in terms of this thing about, what are you talking about? China. None of that is true.
He made a fortune in Ukraine, in China, in Moscow,
that is simply
and various
not
other places.
True.
Lie.
So it's from two different debates, but I mean, Trump was right. I mean, he did make a fortune from China, and Joe Biden was wrong. I don't know that he was lying about it. He might not have been told by Hunter, but this blind spot is a problem.
It's a problem.
Yeah, it's a blind spot. Yeah, it's just a blind spot there, Jake. He's just like so busy working to save America. He's like a senator and a vice president. He's like working on Ukraine corruption. That's what Joe Biden's working on. Ukraine corruption. Can't even see what his son's doing during his daily phone calls because it's just a blind spot. Who else gets the benefit of the doubt of blind spot? Do you think that any J6ers had a blind spot, got caught up in a blind spot in a moment of emotion? No. Any blind spot benefit of the doubt for Trump? No. Of course not. But tens of millions of dollars coming into the Biden coffers via Hunter Biden exploiting his daddy's position as VP? Well, you know, and lying to us about it, right? Hunter or Joe Biden lying to us. Not saying, I don't know where my son gets his money. I don't know. No, he says he doesn't get it. Turns out he does. Just a blind spot, though.
Problem one, because Republicans aren't going to let it go, that's for sure. But also, these problems are continuing through the legal system. It's not as though this is something that's been settled in other jurisdictions and Republicans are just harping on it. It is an ongoing thing in our courts. It's not going anywhere.
This is a blind spot. Does it concern you as a Democrat?
Well, I think dads have sometimes, and parents sometimes have blind spots about their kids, for sure, and the president may be no exception. But
yeah, Hunter, you know, like that first joint that he had under his pillow or something like that, maybe that was a blind spot. But, you know, a whole career of prostitution and being in and out of treatment centers, so many, in fact, that they wouldn't even admit how many it was during his plea deal. The judge said, how many times has he been in treatment? And the defense was like, a lot, Your Honor. Like, I don't know, a lot.
But nothing has tied the president to any of Hunter Biden's dealings. There's no whip.
No, it's not just the copied emails. It's not the phone calls. It's not the golf events. It's not the dinner photos. None of that.
Of him being involved or him being implicated in it. And it's, you know, I think it's not something the voters care a lot about.
All right, we'll see about that. Yeah, just little blind spots for these individuals who are defending the Bidens until the end of the days. And of course, there will be much more to come on that. We've got Hunter's lawyer very upset with Morning Joe for asking about the $7 million. Comer says we're continuing to investigate this. James Tapper finally admitting, you know, Jake Tapper admitting Trump was right. Biden did in fact lie. And so, my friends, we'll continue to cover. Thank you for subscribing. Thank you for following along. Thank you for liking this video wherever you're watching it. And we'll look forward to seeing you on the next one. All right, my friends. Well, that is it for us on this lovely, lovely Friday. We had a nice update from Hunter's lawyer. Spent a little time on him. We got the federal removal order granting a hearing for Mark Meadows and presumably the other co-defendants when they file a similar one. And Donald Trump's lawyers filed a majorly amazing scheduling memo articulating why 8 barrels of Washington monuments of documents is just a little bit too much to read through in 4.5 months. But now, my friends, let's hear from you and see what you have to say about all of this before we go over to our members-only after party at watchingthewatchers.locals.com. YouTube members, join us on the Telegram link, so go over to the community tab section. And hey, YouTube members also, by the way, in the community tab section, there is a form, a survey form for our interview, members-only interview with my friend Sanjeev. We call him Jeevers tomorrow. So if you want to fill that out and get some input on what our interview should be about, check out that link there. We posted it on Locals too. But now let's hear from you and see what you have to say about all of this and more. We had Barb Loves Alaska. That was from yesterday. Barb said, thanks for covering the doc, and you're welcome, Barbs. Thanks for sending that one in. We have a couple other ones. We got some people joining up over on Telegram. Welcome aboard. We got Signo, Carol, Buddy, Cynthia, Ginger, and Brett joining us on Telegram. Welcome aboard. We got Rocky Water. Says, I made a racism, my bad, racism jar +1. Yeah, but that's, I don't know what you did or what you said. I appreciate your honor system. I'm also pretty sure everything's racist these days, so who knows. Patrick Parker says, Robert, the next AG of DOJ. I'll take it, man. It would be the easiest job. I would fix that whole entity my first day on the job. Walk right in and say, guess what, everybody? Thanks for showing up at this meeting here today. Got one big announcement for you. You're all fired. Go home. That would be it. Cases dismissed across the board, Your Honor. There's no more DOJ. Have a great life. All right. We go on. Sylvia McClellan says, welcome, Sylvia, as a supporter. We'll see you tomorrow on, hopefully on our after party as well. We got this one from Jameson. Says, Robert Barnes on D-Day Cobra tonight, 11 o'clock. Don't miss it, my friends. Check out D-Day Cobra with Robert Barnes. Should be a good doozy. We got Scott Ross over as a supporter. Good to see you, Scott. And we'll see you in the Telegram and in our members-only interview tomorrow. Should be fun. Daryl's here. Says, it's death by 1,000 cuts. That's exactly right. Multiple jurisdictions, multiple lawsuits going after all of the different individuals who are involved, all the lieutenants involved. Go after the Michigan alternate electors. Go after the 18 co-defendants for Trump. Change the election rules in multiple different states. Guys like Mark Elias filing lawsuits. You've got charitable organizations raising millions of dollars, voter registration drives. It's an all-out assault. It's a lot. We got Dolphin Fan is the man, bringing in 5 new members. Thank you, Dolphin. Third Proverbs coming in. We got Deborah Myers, Patrick R., Bigfoot Hawk, and Anthony all joining us as members on YouTube. Thanks to Dolphin Fan is the man. Tara Rayner says, some labels with relevant docs and comms provided to Trump shall include Nancy, Chuck, Mitchell, Milley, Bowser, and Pence to and from anyone. Yeah, those would be good emails to get. Yeah, we'd love to subpoena Nancy Pelosi and Chuck Schumer's emails. And Mitchell, and Milley, all of them. CFRBW, Rob is in the house, says, I think Obama and Comey met with Trump before the 2016 inauguration and told him to do what we say or we're going to spread this dossier, cause a special counsel, investigate Frams and family, and make you go. And I think Trump looked at them like Neo did in The Matrix when he gave Agent Smith the finger, and like Clint Eastwood, Trump said, make my day. Neo in The Matrix when he gave Agent Smith the finger. When he did like this thing, come to me. And then he whooped his butt. Good movie. Another good movie. Hey, we got movie night coming up too. John McGarvey has been assigned Mission Impossible to select movie night for us. And I think we're going to have an announcement on that at the end of the show. So we'll see what movie we're picking for our community movie night. Should be fun. We got this one from Quantum Thug Life, who is quantumly thug in multi-dimensionals. We've got Nunya Business is coming in. Thank you to Quantum. Mimi Cool Whip. We've got Gore Lady, the Sentinel, And Are You Kidding is also joining us, courtesy of Quantum Thug Life, thugging it out in multiple dimensions. We've got TH Waite is here. Thank you, TH Waite, as a supporter. Welcome aboard. Grab the Telegram link from the community tab so we can see you in the after party. Jennifer Newman here has mic drop pair, baby. Thank you for that one, Jennifer Newman. Mic drop pair in the house, dropping the mic like we own it. Thank you, Jennifer. I appreciate it. We got SD 1985 says, shout out to Jack Smith. You're right, for providing all the ammo to Trump's lawyers. Jack Smith says, destroy all the evidence. 3 months later, oh crap. It was a really good motion. It was a really good filing. I think the judge is going to have a difficult time trying to hold this trial soon, just due to the sheer volume of the filings. A Bad Poet says, if one gets moved to federal court, Trump can go lay some facts down for Fani in clown court and TV, then leave to federal court. Oh man, they would hate that. That's a great point. They want the case, they want these cases to be publicized and televised. And if he pulls it into federal court, you may not be able to get that. Yeah, so a good one from A Bad Poet. Goofy for Jesus says, it's not climate change burning down our country. It's all this pooky booger gaslighting. Yeah. I think you're right about that. I'm not real sure how you define that or what that encompasses. Pooky booger gaslighting. But Rocky Water confirms, in addition to that, shenanigans. Yeah. So a lot. Pooky, booger, gaslighting, shenanigans. At the end of the day, it's not climate change. It's all burning us all down. We got K Beans here. Says, does Trump want the case to go to federal to be able to pardon himself later? This is a great question, K Bean. And I don't know the answer to it. So let's talk it through. So I don't actually know how removal works in terms of what I would guess would happen would be, Fani would still have to be the prosecutor who is leading the case. But because he's invoking, does it translate the charges into federal charges or is it still the state charges? But the judge is, because these are racketeering cases, we have federal analogs for the state charges. So do we morph the state charges into a federal analog once it gets removed? I think either way, Trump is going to have a much stronger argument at pardoning himself if it is under the federal jurisdiction, right? He'd say, I've got, I don't know that there's a good answer on this, because I don't know that somebody who's gone through this process has ever been pardoned before. I don't know if there's case law on this. And if you just think it through, what has another official in American history been charged with crimes in state court and then attempted to remove the case to federal court and then had a president pardon them? That's probably never happened before. So the argument would be that the answer is yes, that it has become a federal case, which brings it under the umbrella of the federal pardon power, and that Trump should be able to pardon himself. Now, I don't think that's the only reason. I think that's probably an added benefit. I think they'll have, federal courts are traditionally a different, I would say they're a different level than a state court. Fani's going to be not playing in her backyard at federal courts. She'll have a difficult time there. But I would make the argument, I would make the argument if I was Trump that I would pardon myself on all of them anyways, even New York, because this is how the laws work now. They don't matter at all. You just do whatever you want to do. If you get power, you just do whatever you want to do and you let the courts settle it out later. So Trump should pardon himself, and if the left wants to challenge that, they can file their lawsuits and they can duke it out in federal court at the Supreme Court. But up until that moment, exercise maximum elbows in the court. We've got Tara says, Barr is suffering from severe TDS and is bipolar. I think he's confused too. It's did you hear yourself? You just gave us 2 examples where Trump is being victimized by prosecutors. And then you say he's floating this narrative that he's a victim. You just said it twice. Cat Rex says, that was one Hades of a subpoena. Shout out to those lawyers. I love how they throw shade on Jackie. I love how they throw shade on Jackie. From Cat Rex over on Locals. Good to see you, Cat Rex, and welcome aboard. That looks like a new name to us. Melody says, I just recently found your channel. I'm so glad I did. Your detailed analysis is outstanding. Appreciate your hard work. Keep it up. Thank you, Melody. And welcome here. Welcome to our channel. Look at this real good puppy you have here. Look at this puppy. Melody in the house. Thanks for joining. I'm glad you found us. I'm glad you're sticking around. And thanks for the dono and the super chat, the support. Rocky's here on Locals. Says, another great one, Rob. Thanks as always. Comment. I wonder how staunch a defense Fani will have in the remand hearing. It makes no sense that she seemed to needlessly go out of her way to make removal all but inevitable. I wonder, does she win with a removal, and might that have been the plan? Fed case makes for no TV as well. I don't think that's part of her plan. I mean, there's no real reason for it. Like the feds are going to prosecute a very similar case here. Like they're actually referencing the entire J6 committee hearing, and her indictment mirrors that in many ways. It's, you know, as even Bill Barr said, it's way overbroad. So like it would almost be having two parallel similar cases in the federal court. And, you know, now that you mentioned that, now it's like, are these two similar charges that are overlapping? And no, not really. You start asking yourself, you know, is he being prosecuted twice for the same offenses in the same federal jurisdiction? And does one of them go away? Like, does Georgia just go away because there's too much overlap in the federal system already with another case? The same, like you can't have two January 6 cases in DC. You got to have one, consolidate those. So maybe by moving this into federal court, now that we're talking this out, maybe it's a racketeering case, certainly, but it's from the same underlying conduct. It's like if you had two DUIs, you had a federal DUI and a state DUI from the same conduct. You might be able to do that because it's federal versus state. But if you remove the state up into the federal level and treat it as a separate DUI, not really. It's the same conduct. So you charge it as the one DUI, which means that case now has to go away. I don't know. Interesting theory. Rocky Water says, cheers to the judge that halted the Biden deal. You're right about that. That's Judge Norika. Cheers to Judge Norika out there. We got Rob says, how did Hunter earn the money he owed taxes on that he didn't pay? Give us a break. Yeah, tell me about it. Well, by selling access and influence. And his daddy got him appointed to everything. Pinot Shay's helicopter tour says, I agree with everybody. Abby says, I agree with Abby. Investigate every government employee. Prairie Pond has been here. Says, too bad, liar, liar, pants on fire isn't a real thing. News would be entertaining. Yeah, if they lie, they just burst into flames, peacefully into flames in their pants because they're liar, liar, pants on fire. I know what you mean. Yeah, it would be, we'd have a lot less liars, I'll tell you that. We got Jack Mack says, welcome, Jack says, I just want to say how frustrated and nauseated I am at listening to some of these disingenuous people justify Hunter Biden making millions selling access to U.S. government decision-making via his pop. You're right about that, Jack. Jack Mack, 13 in the house. It is nauseating, and they just keep going around in circles and circles. The most nauseating of them all is Representative Dan Goldman, who basically inherited all of his money from Levi's, I think, and then now runs telling everybody how oppressed, you know, how he represents the people of the oppressed or something. And he lies like directly to us. He just parses through the transcripts from Devin Archer and then just lies about it. And then they just ignore all of it. No, he loves his son, Jack. Biden loves his son. And he's a recovered addict, don't you know? Thank you for the nice dono. Rocky Water says, cheers to Comer. Indeed, cheers to Comer. Salty Sarge says, how about the $50,000 rental receipt from the Rehoboth house Hunter was renting? Bill's just getting paid. New world. 50 grand for a rental receipt? Oh, gosh. Yeah, I see what you're saying. I don't know, Salty. Hopefully they get to the bottom of it. True Neutral says, meme smiths need to get one tapper saying Trump was right. Post haste. That's a request from True Neutral in the house for the meme smiths out there. Tapper saying Trump was right. Rob says, Democrats were all over Trump and the Trump kids about making money to influence President Trump, Ivanka Trump, sold off her clothing line in business and worked as an advisor to the president for free. Trust Two Kids is here. Says, great stream, Rob. This is to cover my blind spot. Yeah. What's your blind spot? Like embezzling money from Ukraine and getting prosecutors fired? It's a pretty big blind spot. Yeah, hopefully. Thanks for covering it. Salty says, Rob, what is the over-under on how many times a Ukrainian prostitute revived Hunter? I say 6. Thoughts? Yeah, that's a good over-under right there. You know, over-unders, that's a good over-under. So over-unders, you want to split people. You know, how many times, like, did he get brought to an emergency room, or I don't know. 6 is a good one. If it's 6, I would probably take the over on that one for 7. I think 7 is a good one. We got Viantica says, I'll become president and you can be my attorney general. It's an amazing plan, V. We'll have all the problems solved in less than 24 hours. We got this one from Squin. Says, I'd love it if you were to share that documents graph on X Twitter. TGIF, happy Friday. The motion? Yes, I can do that. I can definitely do that. Squin. I'll drop it on, I'll link to the court document. I can do that, no problem. We got this one from George. Praise him, says Two-Face Bill. Talking about Bill Barr just bouncing all over the place. Thank you, George. I appreciate that one. Salty's here, says sometimes you have to look in the past to see the future. Ozzy Osbourne's lyrics to Crazy Train. Ba-na-na-na-na-na. I know how to play that on the guitar. Learn how to love and forget how to hate, from Salty Sarge in the house. Cat Rex says, it's Cat Rex from YouTube. It would not let me leave a comment for some reason, so I came here, LOL, coming at you from both sides. Well, thanks, Cat. I'm glad you made it over here. I thought we saw one of yours come through. Oh, wait, no, we didn't. We saw your other comment from Locals. YouTube, being difficult. Well, Locals is better anyways. We appreciate you coming over to there. We got Prairie Dancer. Says, the federal case already wanting to indict Trump in the election. Then why is Fani prosecuting him in Georgia on election? Isn't that double jeopardy? Yeah, that's kind of exactly what we were just talking about. So that's kind of what we were talking about. So, like, you can't be convicted twice of the same crime. So Trump can't be prosecuted twice for the same crime. It's the same conduct. Now, for federal and state, you've got differences there. And with racketeering and the other charges, right, there might be overlap that allows them to be prosecuted separately. But I don't know about that. I think it is a double jeopardy issue. I mean, it is in that vein. Okay, so we've got another one that is coming in from our friend Tony Hay Munkets. Let me grab that one. Okay, so that message accidentally got deleted for some reason. Let me see if I can pull it up while we're here. All right, so Tony Hay Munkets, I think we accidentally lost your message for whatever reason. So apologies for that, Tony Hay. If you, apparently we accidentally deleted your message. I don't know what it was. I saw it come by. I apologize. So if you send that over to us again, or just drop a question in the comments or send me an email or something, let me know. You got accidentally fat-fingered by playing hooky. That was not intentional, I guess. So let me see if you're there. Are you there, Tony Hay? Do you remember what you asked? Drop it in the chat if you're there. All right. Well, we apologize for that, and it didn't land in my inbox for whatever reason. So okay. So we'll leave it there, my friends. We will hop over to X very quickly to say what's up to our X friends before we jump over to our members only after party, because the clock is ticking away. We're running short on time here today. And so let's say what's up to our friends on X. We have 4 viewers watching, and we have a couple people who dropped some comments. Lori's here, says War and Peace 78 times. Give me Evelyn Wood's course to prepare for this. Joe Biden has been lying laughingstock for decades, says Vientikis. People act like lying's new. Says the only way you could hope to watch that much disc space in the movies is 4 months in if they're all in 4K. Danny McWilliams is here. We got some more memes from Vientikis. Fred Pedamonte's over in the house. James Pepper, Newton Leroy, Mario Urani, and others over on the X. And shout out to our friends on the X over in the house. But that is it for us, my friends. We are going to leave it right there. WatchingTheWatchers.locals.com. We're heading over there for a very brief after party. Shout out to our mods and meme smiths. Vientikis Prime, K Bean, Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, we got Zach Nichols, John Allen, Janik 909, Dog Digger, Donut Mind Me, John McGarvey, and our meme smiths, Sleepy Dog Lee, Geegum Geegum, and Nathan N810 in the house. And that, my friends, is it for us on the day. Members, stick around. We're going to go over to our after party, and members will have our interview tomorrow with my good friend, breaking in the new interview setup to see if we can figure it out tomorrow. But that is it for us on the day. We've had a very busy week, my friends. Had another indictment and just a lot of nonsense. So it is now time for us to break and pause for the weekend so that we can relax, recharge, invest in some fresh air, some sunshine, some vitamin D, some energy, some meditation, exercise, family, friends, whatever it is you do to recharge your batteries, because we got to come back here next week and get back into it all again. And we need to see you here healthy and ready to go so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night and a beautiful weekend, my friends. I'll see you right back here on Monday. Bye-bye.